Credit managers look at a credit application one way. Your legal team or your construction litigation attorney, who you're going to want to be friends with, is going to look at it different ways. Let's talk about credit applications with attorney John Forrester. Hi, I'd like you all to welcome Jonathan Forrester to our class. He's going to be walking us through a couple of the finer points of applications, mechanics liens, contracts, and some of the nuances you're going to need to know. Jonathan, would you mind telling the class a little bit about yourself?
Certainly, Thea. Well, first, thank you for having me here. I appreciate the opportunity. I am a construction attorney. I've been doing that my entire career. Kind of fell into it originally.
Okay, stop. How do you fall into being a construction attorney?
Well, you get asked, do you want to do construction or do you want to do medical malpractice? And I don't have much of a science background, so I chose construction. But fast forward about 12 years, me and another group of attorneys formed a construction law firm about 3 years ago. And so we've really focused on that to this day. So that's what we do. It's the level of law that we play in, and so that's what I've come to hopefully provide a little bit of insight into construction law today.
Well, we're going to definitely pick your brain on some things, so pretty excited that you're here with us. So if we could talk about a few key points on the credit application terms and conditions. First, I've told the class, make sure you always read what's on your own credit application and understand it, because at some point you may have to explain it to a customer.
Sure.
But some of the fine points that you've seen clients get jammed up on in court would be which pieces?
Well, I think number one is just a good point. You certainly want to read that contract and you want to know what's in your terms and conditions. Hopefully you've had someone prepare them, or you at least review them so you know what's in there and what you're obligated to versus what the other party's obligated to. Some of the finer points, you obviously need to worry about indemnification. Indemnity is, in Louisiana, it means reimbursement. But generally, how that works is the other party, you are usually asking another party to indemnify you for their fault, negligence, acts, or omissions. Now, it can get very detailed and difficult. Different states allow different things. Some allow you to require the party you're contracting with to indemnify you for your own negligence. Now that's very rare, and when it's allowed, it has to be very explicit. But I think states are starting to go away from that now. And so you can only get indemnification for someone else's fault. In other words, if someone else commits an act of negligence and you get sued for it, they generally have to pick up your defense costs as well as a potential judgment if there's a judgment rendered against you.
Perfect. So indemnification, you want to make sure you read it, understand it, and if it's on your credit application, you want to be able to explain it to your customer.
Exactly, very true. And be wary of whether the indemnification clause is even valid under the law.
Okay.
Here in Louisiana, if you have certain terms and conditions, just like the sole negligence that we discussed, if that's required in your contract, that whole clause can be stricken by a judge. So then you end up with what you think you had, you get no indemnity whatsoever because you tweaked the language incorrectly or you just pulled a form contract that's not even legal in your state.
What about choice of law venue? And
Sure.
when you're talking about how the payments are going to be made, do you advise to put different attorneys I know I've talked to or different CFOs always want to put, here's our absolute terms, and we've always shied away from that. Do you choose to go after finance charges, attorney's fees? You want to address
Sure.
those all up front, and then we mentioned choice of law venue, which is my personal favorite.
Yes, you certainly want to, and I think it comes back to a business decision, but I always suggest a choice of law because if I have a local entity and all the parties and witnesses are in town, I do not want to go fly to New York to deal with New York law and pay $1,500 an hour attorneys to deal with my case. I want to treat it locally. I want my people to be here, and I want the court to interpret this contract as I understand the law. So certainly. I think when you start going after certain things like attorney's fees, penalties, and interest, it's a business call. You've got a relationship there. Are you entitled to it if you put it in your contract? Certainly. I always recommend attorney's fees because it makes small disputes worth going after when you're in the right. But again, I think that's a conversation you want to have with your management or your attorney to decide what types of clauses and how far you want to dig in when you're in the right.
Well, I'd rather have the option of that choice than not have it at all.
It certainly. And if you have it in your contract and you decide, well, look, person I'm contracting with, I'm entitled to all of this, but let's just get this done. I won't go after the penalties. I won't go after the interest. So that's a very good point. You can have it to protect yourself, but you can always choose not to go after it if you wish.
Okay, how do you address like warranty issues, or maybe addressing restocking or special orders or any of those? Do you recommend putting that into your terms and conditions piece?
I certainly do. And if it's a real cost that you're going to have to incur due to a warranty issue or restocking, it's something that you're incurring. Why shouldn't the party who caused you to do that pay for that?
Okay.
But again, it goes back to, if you want to play nice at the end of the day, you don't have to enforce those terms, but they're there to protect you in the event that you need them.
Okay, so if I were to say, hey, when you went into court at some point and you had to defend a credit application, what might have been one of the biggest challenges you've had with that credit application? Well, I know you're not going to name the client because, you know, you're going to remain friends with them, but nobody likes their stupid out there, but how did that work?
Well, what we see a lot, and I think it just goes to contracts in general, is you're working under a document, but someone forgot to get the signature when they put it in the file. So you may have gotten verbal approval, you got an email, you talked about it, the contract gets issued, and off to work you go, and you don't get a final copy of that document. So among just not understanding what you agreed to in the contract is make sure the person that you're contracting with has the authority to sign that document.
Okay.
But it can run the gamut from any other issue, indemnity, warranty claims, and then what is supposed to be provided. What was the scope of that agreement? There sometimes is a misunderstanding of what was actually agreed to, what's being provided and what isn't, which is then you can get into exclusions and qualifications, but that may be for another day.
Well, which kind of brings us to another good point that I'd like to bring up, and I hear this from a lot of credit managers, is I have to have a wet signature on a hard copy. And with more and more companies going to PDF fillable online, using DocuSign or Conga or any of those, do the courts still look at those like it's a wet signature? Are those valid? Are some of those fears just unfounded?
I think much of it is unfounded, but the answer is it depends by state.
Okay.
Here in Louisiana, electronic signatures, electronic emails are writings and contracts in Louisiana.
Okay.
So there's no issue here. Now, if you're going to a clerk of court to record a lien, it may not be law, but here in New Orleans, they're going to require a wet blue ink signature.
Really?
Even a wet black ink, they're going to reject it. So even though the law may say electronic signatures are valid, a clerk who may not even be aware is not going to accept that here.
Okay.
But under the law, contracts, you just need to know what your state allows. If it allows electronic signatures, then that's perfectly valid.
So credit applications and contracts you'd be safe on. Mechanics liens, you're going to want to pay attention to what's specific in your state, of even right down to, we talked about font and ink color.
Certainly, yes. You need to be aware of what are the requirements to make a valid contract. And that's a very simple thing. Go to an attorney, and if you're dealing in construction, go to an attorney who knows construction law, but this is a basic tenet of what is allowed for contracts, electronic versus actual signatures.
If you had one piece of advice to give a credit manager who is new to the industry, new to credit management, new to the LBM construction space, what advice would you give them in dealing with first credit applications and then maybe a little bit on contracts? Because they are two different things.
They are.
But they have a lot of similarities just in the T&C.
Sure. Well, I think for the credit applications, you want to go to someone who knows that business. So if you're just learning this business and how that works, it is a unique contract. And so you need to find someone, whether it be someone like you or do a nationwide search, to find someone who can help teach you how this process works, because it is a unique contract. And you could go online, you can ask mentors, get on LinkedIn, but find someone who knows that. In general, for construction and for contracts, just find a good attorney who knows construction. You don't have to pay him a retainer. You can pay him by the hour here and there as you need questions. But I have many clients who just call me at random daily. Hey, I have this issue that's popped up. What do I do? And it's a 2-minute phone call, and they're done. You can go about your day. But another thing on that point of doing this search, I mean, we're here with Level Set right now. They have a network. They have the notice provisions, lien rights. They have resources that I've looked at before. And you can actually go to Level Set if you're looking for additional information. And they even have options where you can go and type in your question, and it will go to an attorney in that state to answer that question for you. So that's another resource available.
I do love that option. It also allows you to find an attorney in the state that you're working in that can help hook you up with the information you need.
It does.
The big challenge with everybody in credit, is to make others understand that you've got to start with that credit application. You've got to start thinking like a bank. I'm lending you money. Unless you are paying for whatever you're taking out of this building or whatever group of technicians or service guys I'm sending out to work on your project, unless you're paying for them up front, I am extending you credit. You didn't give this to me because I'm the cutest person in the room. You gave this to me because of the quality of our work and our reputation. So I need you to come to the table and do what I'm asking you to do. We need these documents. As a credit manager to a contractor or a subcontractor, you're gonna wanna watch twofold. When your salesman does that bid and then gets the proposal, gets awarded the job, that contract usually comes with it. You're gonna wanna try to get that credit application in front of them before that. So if you can start coaching your salespeople, hey, if you're trying to engage this contractor or you're trying to bid different jobs with different companies, get them to fill those credit apps out in advance so that you're not getting those at the same time. You're gonna be under the gun if you do. It's gonna take a little bit of credit magic. Not that you can't do it, I have faith in you, but it'll make it so much easier on everyone if you can separate those two processes. And then you can also help your salespeople, because most of them are commission-based. You can also help them, hey, this group of customers has excellent credit ratings, their jobs don't get liened, they've got all of these positive things behind them. Let's bid their projects more than some of these other guys that have a trail of dead bodies behind them. This is just a small taste of a much larger class. You can take the full class for free at levelset.com. Join me.